Welcome, everyone. I'm going to get us started. My name is Barb Van Hoy. I'm work for the City of Colorado Springs Housing and Homelessness Response Department. And we are so grateful for all the community partners that we work with to put these Renter Rights 101 classes on. We typically do these about 4 times a year. And we especially couldn't do them without Attorney Clinton Albert, who is with Colorado Legal Services, who provides his great expertise. So these events are sort of co-produced and sponsored by Colorado Legal Services, Pikes Peak Library District. Thank you so much. Deb Hamilton is in the back. The Justice Center, Colorado Housing Connects, the Colorado Economic Defense Project, the Area Agency on Aging, the Independent Center. We have some folks here from the Independent Center, Silver Key Senior Services, and we also are joined by someone from the 4th Judicial District program. So we'll hear from her also in a minute. What we typically do is just spend a very short amount of time with all of the organizations, providing you with a quick overview of the services and support that they can provide. And we try to do that really quick because Clinton, there's more and more laws for Clinton to go over and to talk about, and we want to leave time for questions. So I will pass on very quickly to, how about the Independent Center? Would you like to come up? Would you be willing to come up real quick and just say what you provide and where people can find you? We also, when we send out these slides and the recording, we'll send out links to all of the web pages of the partner organizations.
My name's Aurora, and I'm actually in the housing department at the Independent Center. We administer about 600 housing vouchers. We're a nonprofit organization that helps with disabilities, and we help create independence by leveraging people with their own unique abilities. We are home of civil rights for people with disabilities, and we're one of 9 centers for independent living in the state of Colorado. Our 5 core services are information and referral, peer support, advocacy, independent living skills, and transition services. We do housing, benefits assistance, home modifications. We have a deaf and hard of hearing department. We do outreach in the community and all across Southern Colorado and El Paso County. Healthcare at home and veteran-directed care. If you guys want more information or anything like that, I do have a bunch of brochures in the back and information. And of course, you can find us at our website too. So thank you.
Thank you. Deb, do you want to talk about the library?
Hi, everyone. My name is Deb Hamilton. I'm the law librarian at Pikes Peak Library District. So our downtown location has a legal research collection that's free and open to the public. So you can come in and research statutes, print off court forms, all kinds of things. I have my card in the back, so feel free if you need a little help getting started. I can't give legal advice, but I can help you with legal research or connect you to any of the organizations that you hear from today. I'm also going to give a quick plug for the Justice Center since they're unable to be with us today. They have a weekly call-in clinic that's every Wednesday night, 7 p.m. to 8:30. The number to call is 719-473-6212. All right, thanks.
And then Risha with Colorado Housing Connects.
Hi, everyone. I'm Risha Bohannon with Colorado Housing Connects. Usually what we usually do is Monday through Friday from 8 to 4:30. We have the 844 number that you can call. We can send you some resources within your community, all of Colorado. We are primarily based in Denver County and surrounding counties in Denver. So we have affordable housing in Denver. We do paint-a-thon once a year, and then we do home modifications. And then if you're looking for like rental or utility assistance, we can refer you. Unfortunately, we did run out of funding for utility assistance, but catch us in the next cycle and we may be able to help you with utility assistance. Paint-a-thon is once a year. We help, I want to say it's 62 and older. You have to be qualified, and we paint your home. Yes.
Thanks. And I'll just add that program in Colorado Springs is partly funded through our office with some of our federal funds. So homeowners who qualify can also get repairs done, and that helps them also qualify for Paint-a-thon. And I think, is there anyone else either here or online who is with one of the partner agencies? Sometimes we don't always know who's coming. Okay. Yes. And are you going to introduce that program, or we have come on up? Sorry, I wasn't sure.
All right. We have a late addition to the programming this afternoon. So I'd like to introduce Charlene Best from EDI Care.
Thank you. I'm Charlene Best. I'm with the 4th Judicial Court Assisted Recovery from Eviction Program. These flyers are already in the back here. So our program helps people who are going through eviction. I can share information with you. When you reach out to me, I can share information with you about the different evictions timelines, procedures, process, different options you may have to respond to the legal eviction process, and then also get you referred out to our community partners who may be able to help you through that process. So a big part of what I do is share information with you. I can check on the status of eviction cases and tell you, verify if there's an active eviction case in the court for you. And so we do have a brand new tool, which is it's an automated answer form, and it, believe it or not, I would think with technology, be more readily usable and available in Colorado, but it's actually the first of its kind. And so in Colorado, in the judicial system. And so when you grab a form, reach out to me. If you don't have legal representation, like walking you through the eviction process, it might be a nice option for you to use the automated answer form for yourself on your own, because you plug in questions. It helps you come up with a valid legal defense to respond to the court. And so I'm Charlene. You'll find my information at the bottom of the flyer. The first QR code on this responding to your eviction. The first QR code has a little 2.5-minute animated video about your 3 main options. And then the second QR code is that automated answer form tool. So if you guys are working with direct clients, this can be phenomenal in getting this in their hands if they're not able to get connected to Colorado legal resources in time, especially. Anybody have any questions? Yes. Mediator. That's out of my wheelhouse, but we do have mediators in our program. So we do offer a free mediation program. That's on the other flyer. We have 2 flyers. And so if you are able to get your landlord to engage in a mediation with you, we do offer free. We won't charge the landlord. We won't charge the tenants. However, the mediation you have to be signed up for by the landlord. So the landlord does have to agree to engage in that mediation. That can be a nice platform to use before one gets into the court process, especially. Great question.
An eviction on a person, such as they won 11 years ago, will that keep me from being able to rent it now?
No.
Thank you.
Welcome. We'll cover that in the rental application fairness act slide.
If you were trying to do end your lease early based on other.
Correct. Correct. The mediation program is based more for eviction diversion, not so much in the midst of a tenancy itself.
Thank you.
Thank you, Charlie.
Thank you. All right. Well.
All right. Afternoon, folks. My name's Clinton Albert. I'm an attorney with Colorado Legal Services. Let's jump into it because, as you can see, if you picked up a copy of the physical slides, there's a lot. So keep in mind here, this presentation is for informational purposes only. Housing issues require a thoughtful analysis of both the law and the facts of the case and the law that applies to the case. So if you are facing a housing issue, you may contact Colorado Legal Services for possible assistance. You can apply online at our website, over the phone, or in person at our office during business hours. All right. So before we get started, we're covering a lot of material today, a lot. I am not taking questions until the end. All right. If you have a question, write it down. If you don't have paper, grab one of the slides, the sets of slides that I printed out, because you can see it's dense material. We're not going to cover every slide either, but I wanted that to be there. That way y'all would have the information as a resource down the line if something were to come up. So I wanted to start this afternoon with talking about the large changes and new protections that have been added over the course of 2025. These are centered around additional protections and rights for victim survivors of gender-based violence. So first of all, it is not an unlawful detention of real property if the tenant is, and sorry, I speak fast. So if I speak too fast, put a hand up, yell at me, slow down. All right. Unlawful detention of real property, that's eviction. So if somebody is found to be in unlawful detention of real property, that's kind of the legal phrase here that's going to lead to an eviction. That's going to lead to a judgment for possession. So somebody is not going to be able to be evicted if they're a victim survivor of unlawful sexual behavior, domestic violence, domestic abuse, or stalking, and that was the cause of, contributed to, or resulted in the lease violation, and that this is documented. Landlords are able to evict the person who committed that gender-based violence, but not the victim survivor. All right, so I indicated on the last slide, there must be documentation to establish this. This slide is laying out what type of documentation does establish that somebody is a victim survivor of gender-based violence. That's going to be a valid civil protection order, criminal protection order, emergency restraining order, a self-attestation affidavit, or a letter signed by a qualified third party. Self-attestation affidavit is what it sounds like. That's an affidavit, so that's a document signed under the penalty of perjury. This does not have to be notarized. It just has to be an affidavit that indicates that as a tenant, you are the victim survivor of unlawful sexual behavior, stalking, sorry about that, typo, domestic violence or abuse, and that the incident is the cause of, contributed to, or resulted in the alleged lease violation, unlawful detention of real property. Also, if you know the name of the responsible party and it is safe to provide that name, you also must include that in the affidavit. Great, an advertisement. Thanks. All right, so that's the self-attestation affidavit. There's also letters signed by a qualified third party. So this is not so much a police report, but this is going to be victim service provider, an attorney, a social worker, medical professional, faith leader, or a mental health provider. And there are some key qualifiers here. This must be an individual that you sought assistance from related to the incident. Okay. The letter must state that this third party believes that the incident occurred, and also that it is the cause, contributed to, or resulted in the alleged unlawful detention. So this third party has to kind of lending their credibility to this letter, saying, yes, we've done an to an effect. Yes, I believe this has happened, and yes, I believe this is caused to the grounds for a possible eviction. All right, so one of the big protections stemming from this is that if non-payment is what the issue is, and the tenant provides that documentation of being the victim survivor, then the landlord must offer that tenant a repayment plan. The repayment plan must be offered no later than 3 business days after the demand for unpaid rent is served, or after the tenant provides that documentation that they are that victim survivor. Within 7 days after the tenant gets this repayment plan, they don't have to accept it as it stands. All right, because within 7 days, the tenant can then send a counter proposal plan to the landlord. If the tenant accepts the repayment plan, and sorry, let me back up a second here. Once there's no more negotiation after that counter proposal, once the tenant sends that, that will become the repayment agreement. And once that is solidified, then if the tenant accepts the repayment plan, then either party has to notify the court and the court has to vacate any judgments. If there's an agreed upon payment plan, then the court's not going to enter any judgments. All right. So if a landlord does not offer a repayment plan, this is a defense against an eviction. Right. So it is a defense against an eviction that a repayment plan was not offered after documentation of the victim survivor status was given to the landlord. But this defense is then waived if the tenant does not accept the landlord's repayment agreement and the tenant does not propose an alternative repayment agreement within those 7 days. All right, so I kept mentioning repayment plan, payment plan. What are the terms of it? All right, well, it can be no longer than 9 months long, so 9 months at a minimum. It has to require a monthly payment each month. The minimum monthly payment is $25, and it must account for all unpaid rent. So in theory, you could have months 1 through 8, if 1 through 8 be $25 and month 9 be the rest of it, kind of like a balloon payment. And that's going to meet the legal requirements for a repayment plan. During a repayment plan, there may be late payments. If there are 3 late payments, that will be grounds for being evicted for not following through with the repayment plan. So if a payment's more than 10 days late, it's 10 days after the due date is late, 7 days after the tenant does not pay as agreed, or after the 3rd late payment, the landlord may demand all remaining owed rents be paid. If they don't pay all remaining owed rents within the 7 days, then may file a motion for entry of judgment for possession. This is not a done deal. If there are other defenses against the non-payment, they would still be applicable here. And then also, if there's any kind of collections actions after the fact, landlord shall not pursue a claim for money unless the repayment plan is not complied with. This is a slide we're not going through. This is a definition slide. Here are the definitions for domestic abuse, domestic violence, and stalking. Demands for compliance. If this is a demand for non-payment of rent, the demand must also now include this advisement, that if you are a victim survivor of gender-based violence, you have a right to a repayment plan to repay unpaid rent for up to 9 months. So this must be in every single demand for payment that a landlord provides moving forward. Serving a demander notice. All right, so if the tenant provides notice, or if a landlord is aware that the tenant is a victim survivor of gender-based violence and the landlord is trying to serve a notice or demand, then they have to personally serve the tenant who gave the notice. All right. If you can't personally serve after 3 attempts, that's an additional day of trying personal service. Then you can serve by posting, and you must mail a certified or commercial mail courier, providing the notice include. You have to guarantee delivery. So if you're going to post it, you then also have to mail it, and it has to be mailed with some kind of tracking to demonstrate proof of delivery. The thought process here is that in some instances of gender-based violence, the act of coercion or control is going to be to keep a lookout in the apartment and come rip anything off the door. That way the person doesn't know that they're at risk of anything. If a victim this part of the law is retroactive. If you are a victim survivor and you have a prior eviction, you may petition the court or move the court to suppress it or to keep a court suppressed. So that would require the documentation previously provided and an assertion that public access to the records pose a risk to safety of the individual or family member in the household. So that if that happens, then the court shall suppress or continue to suppress any records. Summons. So if the landlord has notice that the tenant is a victim survivor and they are moving forward with filing an eviction case, they are required to serve a summons and complaint. However, they may only serve that summons on the tenant who provided notice. So this is a situation where it's no longer acceptable to serve a family member over the age of 15 if the landlord has noticed that the tenant is the victim survivor of gender-based violence. There also must be required language regarding the right to a possible repayment plan and information for the address confidentiality program. All right. If there's a default judgment in an eviction, a default judgment is when the tenant doesn't file anything to contest the eviction. The court date comes, the court date goes, and nothing's been filed. If the tenant files a motion that they did not file an answer on time because they are that victim survivor and did not receive or have a reasonable opportunity to review the summons and complaint, or was otherwise unable to appear, then the court shall vacate any judgments and or writs and provide the tenant with at least 7 days to submit an answer. The otherwise unable to appear language does tie back to the gender-based violence. It can't be like, oh, I just forgot. But I also was, assaulted 3 weeks ago, and that's led to this. It's got to have that tie, that nexus to it all. Normally, if a tenant files an answer, they're not able to file a second answer saying, oh, wait, but I kind of forgot about this defense. However, with being a victim survivor, if it is a defense related to that, then tenants are allowed to file an amended answer, and the court shall permit that. Then we get to scheduling a hearing. So this is also a bit different. Normally, it's supposed to be 7 to 10 days from when a tenant files an answer. But the tenant may request a waiver of this if the court finds good cause or if you disconnect during a hearing. The waiver is not mandatory, so that's up to the court's discretion. If the tenant just asks, hey, can it be longer than 10 days, or I disconnected while in the hearing. But if a victim survivor asserts a defense pursuant to domestic violence and requests an extension of the hearing date, then the court shall find good cause exists and make all reasonable efforts to schedule the trial date to accommodate any safety concerns raised. The writ of restitution is going to be 30 days and not 10 days, as it would normally be. They must be executed between sunrise and sunset. And then any filing from the plaintiff that contains a writ, must contain a written statement that identifies the tenant as a victim survivor and a specific statement that the writ will not be able to be used for at least 30 days after it is entered. Security deposits. The victim survivor is not going to be responsible for any damage caused to the residence by the abuser. Also not responsible for any damage during the course of gender-based violence. Landlords can only make deductions that comply with the law, with the protections for survivors. And if a lease is terminated early, a landlord only has 30 days from the termination of the agreement to document any actual economic damages that can be retained from a security deposit. Also, the security deposit is presumed to go to the, if the victim and the abuser are both on the lease, the security deposit is going to the victim. But the landlord, as a landlord, that doesn't mean you're just out the damages. You just have to pursue those damages from the abuser in that situation. We've got debt assignment here. Again, landlords can't assign a debt owed by a victim survivor unless it follows the requirements of documentation and provides at least 90 days written notice expressing the intent to assign a debt. Notice must be provided by the preferred method of communication from the tenant or the last known email. Right to privacy. If you tell your landlord, I'm a victim survivor of gender-based violence, the landlord's not allowed to disclose that to anybody. They need express written consent from you, the tenant, to disclose that, or if the court orders that be disclosed. If you tell your landlord it's okay to tell the court this, then the landlord must tell the court in any pleading or after such time that you are a victim survivor. Also, on a rental application, landlords are not able to ask about this as part of your past. As an early termination, this allows also the early termination of a lease agreement, and the victim survivor may terminate a lease or rental agreement anytime prior to a court's eviction order. What this would mean then, in practice is that if you are going through an eviction case and you are on the cusp of moving out, you provide notice to terminate the lease and you move out, that would make the eviction case moot at that point because you've given possession back. All right. There's also safety measures here. A victim survivor is able to take appropriate non-permanent make non-permanent modifications to the residence for safety purposes, such as changing the locks, installing window bars, installing cameras, installing other non-permanent modifications. And landlords can't prevent these actions. They can't charge fees. They can't take any kind of retaliatory measures against that. It's not a material lease violation to make these changes either. But if the locks are changed, then you have to make all reasonable efforts to get the key or the new code, if it's an electronic lock, to the landlord as soon as practicable, but no later than 14 days after the change. But if the landlord or the property manager is the abuser, is the responsible party, do not have to give the responsible party a copy of the new key. And shall make reasonable efforts to provide a copy of that key to another individual who has authority to manage the property and who the tenant determines is safe. If you feel that you're in this type of situation, I would recommend documenting what's happening and also to seek out perhaps legal advice from the Justice Center's Call a Lawyer clinic on Wednesday nights, just to kind of double check your math for cliche purposes there. If there's a violation of these new protections, then there are potential lawsuits, such as the greater of 3 times the monthly rent or $5,000, punitive damage, attorney fees, and any costs. All right, so that's kind of a very brief overview of the newer protections that have come into effect throughout this year, the repayment plan being one of the most significant ones, because if that does happen, that would end the eviction case and put the victim survivor on a repayment plan in hopes of stabilizing the tenancy. So let's kind of take a step back and look at the tenancy as a whole and just kind of go through it from start to finish and issues that you may run into. Before you move into a new place, oral leases are valid. I would really try to put something in writing though. All right. If there's any specific terms, it will be very difficult to prove them if they are not written down. So the best practice is to have a written agreement. Applying for a residence. So when you're applying for a residence, there are guidelines, there are rules. So fees cannot be charged unless it uses the entire amount. If there's any kind of leftover, then the landlord must make all reasonable efforts to return that to the applicant. Landlords can only require income of 200% of the tenant's portion of rent. All right, portion. I saw a furrowed brow back there. That's because vouchers. So if a tenant has a voucher, then the landlord cannot say, let's say it's $1,000 rent, voucher covers $750. Tenant's portion is $250. Tenant's income is $750. Landlord can't say, oh, we need 2 times the rent. That's $2,000. You make $750. We're denying you. No, the proper math there would be your portion would be $250. So we're only requiring $500 a month in income. Landlords are able to ask about income for determining eligibility for income restricted properties, low income housing tax credit properties where they have like a 50% AMI as the maximum income of a potential tenant. Cannot consider credit score, adverse credit event, or lack of credit score unless required by federal law to consider a credit score. No consideration of credit history that is older than 7 years. If you have an eviction judgment from 11 years ago, that is not a basis to deny anything. As far as criminal history, no arrests can be considered. You can have 1 million arrests. That's got to be exhausting. But if that happens and none of them are convictions, there are 0 reasons to deny an application. But if there are convictions, and any conviction within the past 5 years is going to be grounds to deny an application. If a conviction is older than 5 years, it is not a reason to deny an application unless that is an old conviction for like methamphetamine related offenses. Generally speaking, I'm not talking about simple possession. I'm talking about distribution, possession of precursor materials, any kind of creation or distribution. Offenses which require a person to register as a sex offender pursuant to Colorado statute, homicide-related offenses, and stalking. If you have one of those, that can follow you forever and be a reason to deny forever. If the law is not followed, then there can be possible penalties listed down there. All right. When we're applying for a residence, there's what's called a portable tenant screening report. This is a consumer report for a tenant to provide to multiple landlords. So instead of paying 8 application fees, you can pay for one tenant screening report and give it to 8 different landlords. All right. This is a report that includes your name, your contact information, verification of employment and income, your last known address, rental, credit, criminal history, conviction for each jurisdiction indicated in the report as a prior residence. Landlords are required to accept this report. They cannot say we're not taking it. There is an exception there if they only take like one application at a time and then refund all the application fees. But they are required to accept it. They may require that the report be made completed within the prior 30 days, that it be made directly available to the landlord at no cost to them. And they also may require a statement from you as the applicant stating, hey, there's not been a material change to this report since it's been created. Not allowed to charge any fee or fee to access or use the screening report in application. You can't be charged to use this. And also landlords must tell you or advise applicants that they have a right to use this screening report. Can't charge an application fee if you use a screening report. Can't charge a fee to use a screening report. And the advisement has to be in a location and delivered in a method likely to reach applicants. Written advertisements, homepage of a website, online advertisements, or orally to an applicant followed by a written confirmation. There are exemptions. They don't have to. This is the exemptions we were talking about. Do not have to accept portable screening reports if it only accepts one application at a time and refunds the total fee to each applicant within 20 days of declining an application. So this is kind of the narrow situation where they don't have to accept a screening report. But in this situation, you can see that if you pay an application fee, the entire amount gets refunded to you. So you're not out any money there. All right. Now we've gone through the application. It says we've been approved. They hand us that big old 70-page packet, 18 addendums. Looks like a textbook, except it's in 0.8 font. Read everything. Read it all. I don't care. I know what I just described. I know how burdensome it is. Read it all, because that's what you're agreeing to. And if you find yourself in some kind of legal dispute, it's not going to be any sort of defense to say, I didn't read it. I didn't know it was in there. Because when you sign the lease agreement, what you're saying is, I agree to all of the terms. I know it's going to take a while. I read leases all of the time. It does take a while. Take the time to make sure you know what you're signing up for. All right. Just very briefly on options to purchase. If you're considering an option to purchase, a lease with an option to purchase, I'd seek counsel prior to signing it. That way you make sure you know what the terms of it are. I've spoken to folks over the years like, well, no, we have a lease to own. We're working on owning the house. But then when we go through the lease agreement, there were certain extra steps that needed to be taken and they weren't taken. So I've seen folks be heartbroken when they've lost tens of thousands of dollars that they put into a property because they didn't tell their landlord, we intend to buy this. All right, here's a list of things also in reading through a lease agreement. There are certain things that are not enforceable, right? If this is in your lease agreement, it may be concerning, but it is not something that can be enforced in a court. You can't waive your right to the return of a security deposit, the warranty of habitability, the covenant of quiet enjoyment, a written demand for unpaid rent, the court process for eviction, late fees greater than $50 or 5% of the late rent, unreasonable liquidated damages clause that assigns a cost stemming from an eviction notice or action, a one-way fee shifting clause for attorney fees that must go to whoever wins a case. The right to a jury trial, except you can waive a right to a jury trial for possession. That's the eviction phase. The ability to join joint, class, or collective legal actions relating to the term of the tenancy. The implied covenant of good faith and fair dealing. implied covenant of quiet enjoyment, any fee for not providing a notice of non-renewal for the end of a lease, a provision that characterizes any fees for utilities or services as rent. Any rent is rent. You can't say that your utilities are rent. Rent is the money that you pay for the roof over your head. Anything beyond that is not rent. You can't have fees that require you to pay extra for a third-party billing service, except may charge a fee no greater than 2% or up to 10 months, but not both, or up to $10 per month, but not both. Voucher or subsidy providers cannot pursue an eviction for the non-payment of utilities. All right, there are some required lease clauses. Must have a statement regarding that Colorado law prohibits income discrimination and requires landlords to accept any lawful and verifiable source of money. That doesn't apply to landlords with 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family rental homes. We've read it. We've signed it. Great. Make sure you get a copy of it. If it's digital, make sure you save it somewhere and you keep it backed up. All right. The law requires your landlord to provide you with a copy of your lease within 7 days as well. But just a question that comes up from time to time is what happens when the building is sold or if my landlord changes. If your landlord changes, but the ownership remains the same, the new landlord, let's say it goes from property management company A to property management company B. Company B must tell you the updated contact information to include new addresses for notices, to include an email address. If your new landlord does not do this, contact your landlord to request the information. You want that, we're approaching winter, right? If you have a new landlord and you don't know how to contact them, figure out how to do that now. That way you know what to do or you know who to talk to if something happens, if heat goes out, electricity goes out, hot water goes out. If your building is for sale and your tenancy is jeopardized, that would be where, the building is literally for sale and you probably don't have and your lease agreement has expired and you're just kind of a holdover, you're just a month-to-month tenant, or maybe you're on a verbal lease. You can record your lease with the clerk and recorder. You want to talk to an attorney before you do that. When you go and you file your lease agreement with the clerk and recorder, when your building is for sale, what that does is it puts potential buyers on notice that I have the right to live here. I have a possessory interest in the property, so you have to respect the term of my lease. If it's a 1-year lease, at the end of it, that new landlord can then choose not to renew it. But if you don't have a current lease, then you may want to contact the new owner to propose a rental agreement, because in this situation, they can move quickly on a potential eviction if they were unaware of you as a residential tenant. Rent increases no more than once every 12 months of continued occupancy must be done on it, can only be increased upon 60 days written notice, may not terminate a residential tenancy with no written agreement by serving a notice to quit, with the primary purpose being raising the rent with less than 60 days. This is not so much an issue anymore for longer term tenants when we get to no fault evictions, and that'll make sense when we get there. Late fees. Here are the things landlords can't do in relation to late fees. Can't charge a late fee unless rent is at least 7 calendar days late. Can't charge a late fee that exceeds $50 or 5% of the amount past due. Not the rent, the amount past due. $2,000 rent, 10 or 5% of that would be $100. All right. If you pay $1,000 and only owe $1,000 and you get a demand, it can only be 5% of that $1,000, not 5% of $2,000. Right? Also, the late fees must be disclosed in the rent and the lease agreement. If they are not, they cannot be charged. Can't take somebody to court for unpaid late fees. You can't terminate a tenancy for unpaid late fees. You can't impose a late fee on a late fee. You can't impose a late fee for late payment for a voucher. If the housing authority is late, that's on the housing authority, not the tenant. The landlord has signed a second contract with the housing authority to take those payments. Can't impose a late fee more than once for a late payment unless the late fee is less than $50 or 5% or 5% of the amount past due. Can't charge interest on a late fee. Yeah, and you can't charge a late fee unless you provided written notice of the late fee within 180 days after the date upon which the rent payment was due. You can't go back a year from now. Your landlord can't come to you and say, hey, you know what? We've been going through our records. It looks like you've got a late payment from January of this year. So we're just going to add that onto your ledger. You can just pay that with next month's rent. No, it's past 180 days. It's too late. It's an affirmative defense against an eviction that there are illegal late fees. And a late fee is not rent and cannot be classified as rent for the statute. Rent is the roof over your head. Late fee is not the roof over your head. Penalties for late fees. So if your lease agreement has a provision that is not compliant with the law, all right, it says we can charge late fees on the second day of the month and your rent's due on the first. Well, guess what? They can charge 0 late fees now. Because if your lease is not compliant with the law, then the landlord can't charge any late fees. A landlord who charges any legal late fee shall pay the tenant a $50 penalty for each violation. If a tenant who then gives a landlord written notice saying, hey, this is an illegal late fee, you've got to fix it. Landlord has 7 days to fix that violation. And that time begins when the landlord receives the written or electronic notice of the violation. That has nothing to do with the $50 penalty. That's already done. Okay. What this prevents, though, is if you give the demand letter and if your landlord doesn't fix the problem, then you may start a lawsuit seeking for actual injuries, and then a penalty of $50 up to $1,000 for each violation of the law, and that would be payable to you as the tenant. You can also seek court costs, attorney fees. So this is kind of the world of late fees and what can happen there. It can add up pretty quickly. By way of example, I've had a case in the past where, and this is kind of to highlight the $50 for each violation. The ledger was fixed. Sorry, I'm going to do quick math here. Don't mind me. The ledger had been fixed, so they fixed the problem. But at that point, there had been over 600 violations at that point. So that was $50 per violation. That was pretty expensive bookkeeping error. All right. We've signed the lease. We've read through it. We're okay with it. See you, Barb. Thank you. We got our family out front. We've harangued them into helping us move this day, or friends, or we got the two guys in a truck, whatever it may be. Before you start unloading boxes, before you start unpacking, I'm begging you, take pictures. Go through, take pictures of everything, take videos showing how things work. Why are these important? Because it's going to document the conditions. You're showing what it looks like when you moved in, everything, damaged and undamaged. At the end of your tenancy, when you move out, the last thing you should do before you go turn the keys in, take those same pictures. That way you have the start point and the end point. All right. This is going to be good for any kind of security deposit dispute. If you're told, hey, you didn't clean the banister or you didn't clean this wall, and you could say, well, that's because this is the wall when I moved in. If you can do a walkthrough with your landlord before you move in, I'd recommend doing it. It's not legally required, but just for best practices, you can walk through together. You can try the light switches. You can run the water. You can make sure you can turn on the shower. You can make sure all the water pressure is good. You're getting hot water. And if there are any issues, you can take those notes down and hand them right to your landlord to make sure that they're fixed. When this has happened, be critical, but don't be unreasonable. All right. If you see a chip of paint on the corner, that doesn't mean that the whole place needs to be repainted. But if you have a window that is painted shut, that needs to be fixed. That's a problem. That's unsafe. Also, this is a business relationship. You're paying money to live there. You're paying money for a safe place to live. You're paying money for an apartment that works as advertised. Don't be scared of that. All right. We've moved in. We've unpacked. We're now living there. What are we going to run into throughout the tenancy? Well, one of the main issues, and as we're seeing the clouds roll down the hills today, and we're feeling that chill in the air, the warranty of habitability comes up quite frequently. This is the promise that your residence is fit for human living. There's a list of things that must be present. Here they are. Here's the list. You've got the slides online. You see them. Take a picture. Get a copy of them. All right. here's the process for bed bugs. Okay, bed bugs have their own process. Here's this is process for it. You give notice. This is what has to happen after that fact. If, let's say you have a neighbor, your neighbor reports bed bugs to your landlord intends on inspecting the neighbor's unit and says, hey, your neighbor reported bed bugs, I'm inspecting your unit as well. Comply. All right. Because they can travel and they're nasty little buggers, literally and figuratively. And also landlords are allowed to do that if they are trying to treat bed bugs and you are not allowing them to do that, then you are opening yourself up to a lot of liability. So you have to comply with the measures to treat the place for inspection and treatment. What does that mean? That means you're going to probably get a checklist of, hey, we're coming on this day. Here's what we need you to do. We need you to pull the furniture out from the side of the walls. We need you to bag up all of your clothing and go wash it and dry it on high heat, at least 100 degrees. We need you to tear the fabric off any bottom of furniture. We need you to put all of your dishware in Tupperware sealed tubs. You do have to do that, and that cost is going to be on you. All right. But if you don't do it and you don't let them in and you don't allow them to treat, then your landlord can take you to court and say, Judge, they're not allowing me to treat for bed bugs. And the court could order one, yes, you are going to allow them in, and you're now responsible for that cost and the cost of treating other units as well. Because, yeah, the thought process there is that with bed bugs, if you're not allowing someone in to treat, you are possibly allowing it to spread. Fun subject, I know. So here's landlords may apply for injunctive relief against tenants who don't allow access. That's going to court and saying, Judge, they won't let me in to treat. Judge says, yes, they will now. And you can see here the liability for what happens there. Here's the process for mold. So mold, that is, when we're talking about uninhabitability and mold, that's going to be mold associated with dampness or any other condition causing the residential premises to be damp, which, if you don't fix that problem, would materially interfere with the life, health, or safety of the tenant. This excludes the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning and use. If you got mildew in the shower, yeah, you're going to get mildew in the shower. You got some weird Rorschach test that's coming out of your bathroom or coming out of your bedroom closet. I'm a little more worried about that. That shouldn't be there. Also, there can be mold in the bathroom that's also above and that's also just not okay as well. I don't want you to think, why is the bathroom the free zone? It's not. But mildew's not going to be, mildew's not going to kind of be triggering the warranty of habitability. Appliances are also covered under the warranty of habitability. These are going to apply only to what's specifically listed in your written rental agreement or otherwise actually provided by your landlord at the beginning of tenancy. If you make a demand because your refrigerator broke and they replace the refrigerator and you get it's not the newest top of the line model, that's fine. That's not presumed to be a problem. But if your refrigerator breaks and your landlord gives you the little mini fridge that might fit six Cokes, that's not a refrigerator, then you can't use it the same way. It's not substantially similar. All right, so there's a list of kind of statutory conditions. These are problems. Then there are big problems, right? There are conditions that materially interfere with your life, health, or safety. Some of these are going to be subjective. We're all different individuals. Our bodies are all different, and they all interact with our environment differently. But there are some conditions where the law says, hey, if this is going on, we're going to presume that this is materially interfering with your life, health, or safety. So if there's a lack of waterproofing or weather protection for roof, exterior walls, exterior doors, windows, so that the rain or snow can get in, yeah, that's a problem. Hazardous conditions of gas piping, gas facilities, appliances, or other equipment, inadequate running water or running hot water. There is an exception there where it's a temporary disruption due to necessary maintenance, repair, construction that is being performed, or temporary disruption in water service that a landlord could not have reasonably prevented or controlled. What? It says inadequate running water or running hot water. So it's both. All right, so we're in this period now. If you don't have heat, that's going to be a presumption of materially interfering with your life, health, or safety. Hazardous conditions of electrical wiring, facilities, appliances, or equipment. Lack of electricity or disruptions that are caused by a landlord's failure to maintain electrical equipment. Infestation, rodents, vermin, pests, insects. Inaccessible fire exits or egress in accordance with applicable building, housing, fire health codes. Misaligned, damage, or improper or misaligned chimney, venting, or any fuel-fired heating or ventilation cooling system. Broken elevators when there aren't any other way to get down. There was a building here in town a while ago that had an elevator broken and folks on the top floor were trapped. So they got put up in a hotel while they were fixing it. This is a presumption. All right. So that means that if this goes to court, a landlord can say, hey, this may have been here, but it actually wasn't materially interfering with the life, health, or safety. And here's the evidence to show that. That has to be clear and convincing evidence that it's fine. But that doesn't mean that a court or a jury can't find opposite of that. It's a presumption. So we start from this. The landlord can disprove it and the tenant can reprove it. So when does a breach happen? We've been talking about, hey, if these conditions are here, when does it actually become a problem by the law? Well, we have one of the conditions that were on the previous slides, and landlord has received reasonably complete written notice and has failed to start fixing the problem within required times, or has failed to finish fixing the problem. So when do they have to start? There's a couple different timelines here. First of all, the landlord does have to respond to your notice within 24 hours. Indicating it can be longer if we're talking about a natural disaster, and they can't get to the property, but they have to tell you, I've received your notice. Here's what we're going to do to fix the problem. Here's when we're going to start fixing the problem. Here's how long it's going to take to fix the problem. But if that's they have to respond within 24 hours. When do they have to start doing stuff? When do they have to start taking action? Material interference with life, health, or safety within 24 hours. Uninhabitable by statute is 96 hours. And this is key. If you're telling you have to give permission for your landlord to enter. If you tell your landlord, my home is uninhabitable, and your landlord says, I'm so sorry, I can be by in 3 hours, and you say, doesn't really work for me. How about next Tuesday? Those timelines are now off the table because you've taken them off the table. And also you're telling your landlord, hey, my home is uninhabitable, but I don't really need for it to be fixed right now. That's kind of contradictory messaging. So if you are saying that, if you're saying, hey, I have an issue with my running water, give permission to say, I have an issue with my running water. Please come fix it as soon as possible. My home is uninhabitable. You can come in to fix it. Also, mold has its own timeline. Here's the timeline for mold. It's within 96 hours, but there's a list of specific actions here that must be taken. All right. So sorry, I spoiled this one here for everybody. Sorry about that. Got a little too excited about this. So yeah, has to respond to your notice within 24 hours, and it's up to 72 hours if we're talking about an environmental public health event. Think like mass flooding that cut the property, that has destroyed a bridge or something like that. You can't get to the property or tore up a road. And you just can't get back there right away. Intention for fixing the problem, when it's going to start, when it's going to finish. Also, if you get proof I filed an insurance claim, good for you. When are you going to fix the problem? All right. So we're in this house. This apartment, it's not habitable. It's not safe. What are we supposed to do if it's not safe? We just keep living there? Well, we don't have to. In some situations, a landlord has to provide us with an alternative residence. So if it's a condition that materially interferes with the tenant's life, health, or safety, and tenant makes a request, All right. So you have to make the request. It says, here is my problem. This is material interfering with my life, health, or safety. I give you permission to enter. I am also requesting an alternative residence while the repairs are done. Landlord shall provide a comparable dwelling unit or a hotel room as selected by the landlord at no expense or cost to the tenant. All right. If you have a dog, a comparable dwelling unit must include the dog, because that would be comparable to your current situation of being able to, if you're allowed to have the dog, then you should be allowed to have the dog. Landlord's not responsible for other costs that arise after the relocation period. Tenant's still responsible for rent. If your landlord has breached the warranty of habitability, what are your remedies? What can you do as a tenant in this situation? Because at this point, you've given the notice, your safety's in danger, and quite honestly, you're not getting what you paid for, right? You're not getting a habitable home. You can terminate the lease agreement. Okay. And that's if your landlord doesn't start, you can give them notice 10 to 30 days after the breach saying, I'm terminating the lease agreement and moving out. You can also try to go to court to obtain a temporary restraining order and or injunction for the repairs to be made. Temporary restraining order, not what we normally think about when we hear those words. We normally think about is this person's really threatening my life and my safety, and I want them to be 100 yards away from me at all times. I don't want them anywhere near my house or my job. Well, this is different. This is your landlord. So what we're saying to the court isn't stay away. We're saying, court, the landlord refuses to follow the law. The landlord refuses to provide me with a habitable home. I have taken all of these steps to try to get this done, and it's not happening. This is more for, there's also for life, health, or safety. The court's supposed to just grant that motion on its face if it finds facts supporting it. Can also defend against an eviction for non-payment of rent. There are other monetary options. You can withhold rent. If you're withholding rent because it's uninhabitable, you need to set your rent aside to the best of your ability. Because at the end of a case, the judge is going to make some determination on how much rent is owed. If you are wrong about there being a breach, they're going to order that you pay the full rent within 2 weeks. All right. So if you're withholding your rent money, set it aside. Okay. Set that aside and reserve it for what happens at the end of a case. You can also deduct the cost of a repair for rent. If you're going about this, talk to somebody first. Talk to an attorney first before you do that. Because it's a very specific process. It doesn't apply to every condition. There are kind of rights of refusing estimates. You can't have a professional that is related to you do the estimate or the work. So, and also wrongful deductions or bad faith deductions can lead to an eviction. So it's a very specific process. And to be candid, you're kind of doing your landlord's job for them because you're getting the repairs done. Are there exceptions to the warranty of habitability? Yes. If there's a written agreement separate from the lease agreement that is supported by adequate consideration and the tenant has the skill to perform the work, you can take some things out of the warranty of habitability. Let's say you're an electrician by trade, and so your landlord says, "Hey, I'll knock $300 off the rent each month if you maintain the electrical wiring of the home." You sign that agreement. If you have wiring go out, that's not going to be a warranty of habitability issue because you've agreed to take that specific issue on. At a hearing, after the hearing, if the court finds that there has been a breach of the warranty of habitability, the court then must determine what the reduction of the rent would be from its uninhabitable date to the date of the trial. What's that dollar amount? Then the court's going to deny possession to the landlord, deem the tenant the prevailing party. The tenant has to pay the rent that has accrued to the date and must pay within 14 days. If they don't pay within 14 days, then they get evicted. Breach of the warranty of habitability is also a defense against a collections actions for money. The court may also order the landlord to make and correct the uninhabitable conditions. Don't know what that was. Sorry about that. And if the court does order repairs to be made, then the court keeps the case open and keeps jurisdiction over the case to ensure that they've complied with the court order. All right, retaliation. So when we're talking about retaliation, it's got to be more than a feeling. It's got to be more than maybe an attitude change. There has to be increasing rent, decreasing services, terminating a lease without a tenant's consent, unless it's permitted by law, bringing or threatening to bring an eviction case, taking action that intimidates, threatens, discriminates, or retaliates against a tenant. This is a defense against an eviction, and it's a defense where the landlord is doing this, is retaliating against the tenant for making a good faith complaint regarding the warranty of habitability to the landlord or a governmental agency like code enforcement, or organizing or becoming a member of a tenants association or similar association. You don't have to prove that this was the only reason, but you do have to show that it was a motivating factor that influenced the landlord's decision to engage in retaliatory actions. It is very helpful to have something in writing here. Just saying kind of the mood changed is going to be, that's really squishy. That's something that's not really, we can't really reach out and touch. It just changed. It felt different. That's probably not going to be considered by proof. I can be wrong. I'm always open to being wrong. And here are some other resources if you are dealing with conditions issues in the home. With code enforcement, keep in mind that's not the warranty of habitability. That's enforcement of the cities that enforce the minimum housing standards of the City Code of Colorado Springs. There's a lot of crossover, don't get me wrong, but it's not a one-to-one, right? Mold is not something code enforcement handles. Screens on your windows are. Screens on your windows are not in the warranty of habitability. So it's not a direct one-to-one that everything in the warranty is in the city code and vice versa. Yep. All right, so we're getting to, if we kind of think about, hey, this is what happens over the course of a tenancy, right? We've talked about applying, we've talked about moving in, signing a lease. Well, now we're getting towards the end of it, all right? And one of the big changes over the last couple of years has been this creation of no-fault evictions. So here's the court form for it. This is a JDF 99C. So this clause requirement applies to all tenancies except the following: short-term rentals, employer-provided housing, mobile home tenants that have equity in the home, tenancies under 12 months, tenants not known to be a residential tenant to the landlord. That doesn't mean squatter. That could be somebody who's, say, living in their business, but it's a commercial lease. Landlord has no idea that they're a residential tenant. A property where the owner or the master tenant lives in the premises and it's less than 4 dwelling units. A property where the owner lives in property adjacent and it's less than 4 dwelling units. All right, so that's what it doesn't apply to. If you're thinking, well, I've been in my place for about 2.5 years, does it apply to me? Yeah, it applies to you unless you live with your landlord or your landlord lives next door and it's 4 or less units. If you live in a building with 8 apartments and the landlord lives in it, guess what? It applies to you because we're more than 4 units. All right, what does this all mean? So previously, to end a tenancy, landlord could give you a notice to quit. No reason was required, just different notice periods based on the length of the tenancy. With a notice to terminate tenancy, it has to include the reason for terminating the tenancy, and that reason must be included in the notice. There's a 90-day written notice required from the landlord, and there's limited reasons to terminate a tenancy here. What are those reasons? All right. So it's going to be demolishing or converting a residential premises. So this is when a landlord plans to demolish residential premises, convert it to non-residential use or to a short-term rental. They can take this step if they provide the 90-day written notice, a description of the timeline of demolition or conversion, and a material demonstration of the proposed date when the project will commence. Not just, hey, I'm thinking this is what I'm going to do. Building permits, applications for permits, license to operate short-term rentals. You have to show that the landlord's actually going to do the work. Tenant, in that 90-day period, you remain in place. Substantial repairs or renovations. If a landlord is planning on making substantial repairs or renovations, it may terminate a tenancy. This is all at the end of the lease agreement, by the way. It's all at the end of it. 90-day notice that tells the tenant an expected completion date and a general description of the repairs/renovations that they're going to do. They proceed without unreasonable delay to begin the repairs or renovations after regaining possession of the property. And this is key. If the work's expected to be 6 months or less, then the tenant has the right of first refusal to the renovated property. So landlord gives you the 90-day notice that says, hey, I'm going to be doing a bunch of repairs. I'm going to be remodeling all the bathrooms here, and I'm going to be tearing down this decorative wall or something like that. It's going to take me 5 months to do. And it's going to be finished 5 months from now. The tenant responds, if the tenant says within the next 10 days, hey, that sounds pretty good. I'd actually like to return that. Then I should actually like to come back and move back in once you're done with the work. Then the landlord has to give them the first offer of a lease agreement. All right. And if the tenant then accepts that new lease agreement, once the work is completed, they have 30 days to move back into the property unless there's an agreement to extend that. If the repair work is necessary to comply with the warranty of habitability, that is not a reason to terminate the tenancy. That would create the ultimate loophole of let me make the house so crappy that I force you to move out, and then I get to keep you moved out because I have to do this repairs. Or if the repairs are initiated in retaliation, say, hey, landlord, I don't have any hot water. And they say, okay, you don't have any hot water? Well, I'm going to build a third story. So you have to move out in 90 days. If a landlord or a family member of the landlord plan on moving into the property, they can terminate the tenancy. If they move into the property within 3 months after the tenant moves out, they provide the 90 days, and no substantially equivalent unit is vacant and available for occupancy by the landlord or family member in the same building. And the landlord does not list the property for long or short-term rental for at least 90 days after the date the tenant is required to vacate. If this is active duty military or a spouse, then it's only 45 days. The 90 days to move in can be extended to accommodate the property for a disabled family member or disabled landlord. If we're selling the property, we're taking it out of the rental market and we're just selling it, that can also be a reason to terminate a tenancy. Again, 90-day written notice to the tenant, properly served upon the tenant, does not list the property for long-term or short-term rental for at least 90 days after the move-out date. Does not allow a landlord to terminate a lease agreement early without cause. All right, none of these are workarounds for the lease agreement. These don't create loopholes. If you sign a lease agreement that goes to November 21st, 2026, that lease agreement goes to November 21st, 2026. These aren't ways to cheat that date. If, as a tenant, you refuse to sign a new lease with reasonable terms, that is also a ground to terminate a tenancy. Once you refuse to sign the lease agreement, the landlord can give you a 90-day notice. They have to serve that upon you. During that 90-day period, shall not increase rent in a discriminatory, retaliatory, or unconscionable manner to get around the new law and force a refusal to sign. We've got a history of non-payment of rent. So if a tenant pays rent late more than 2 times during the term of the rental agreement, may terminate the tenancy at the end of the agreement upon 90 days written notice. A rent payment is late if it's more than 10 calendar days after the day it is due, according to the rental agreement, and the landlord provides the tenant with proper service of a written notice. It does not apply if there is a full payment made during the cure period. So if there's a late payment, but then that payment is made after a demand is given, it's no longer late and doesn't count towards those more than 2 times. Here's what a written notice to tenancy looks like, a written notice to terminate tenancy looks like for other issues. So this is not no fault. No fault one listed out those specific reasons. You can see here, this is going to be a lease not being renewed. That's going to be for tenancies under 12 months. Substantial violations, think guns and drugs. Repeat violation, you violated the same lease term within 12 months. So this notice has to include a statement of the legal and factual basis to terminate the tenancy. Must include a mediation advisement, specific description of the alleged grounds, and must be in a language the landlord knows or has reason to know is the primary language. Can't waive this. And any attempt to do so will be void and unenforceable. We're on to demands. All right. So a demand is a document from the landlord stating you have violated your lease agreement. You have 10 and or 30 or 3, 5, 10 or 30 days to come into compliance. Exempt residential agreement means that you're renting a single family residence. And in the lease agreement, your landlord has told you that this is an exempt residential agreement. What that means is that you get 5 days notice instead of 10. So a demand for compliance must include a description of the property, a specific description of the alleged violation, the date and time when the premises shall be returned to the landlord. If it is non-payment, it must include an advisement for victim survivors of gender-based violence to a right to a repayment plan. The demand must be in any language that the landlord knows or has reason to know is the primary language of the tenant. There must be a signature from a proper person. There also must be an advisement regarding the right to possible mediation. There's also, so these are all kind of grounds for a potential eviction. Okay. One of the grounds is kind of one in theory is a quiet enjoyment or a nuisance ground. And this is where we trying to be mindful of time, folks. That way I can get the questions. It's a disturbance or nuisance that interfered with the quiet enjoyment of the landlord, others who reside in an immediately adjacent property, other tenants, occupants of the same property, or the tenant has negligently damaged the housing accommodation. For this to apply to the landlord, they must live in the same property or an immediately adjacent property to apply to the landlord. A demand must provide an opportunity to cure and contain a description of the specific conduct that disturbed others or caused a nuisance. A tenant's lawful exercise of its rights pursuant to any law or rule relating to the occupancy of the property is not interfering with a person's quiet enjoyment or constituting a nuisance. Also, if the tenant's a victim of domestic violence, the tenant is not creating a nuisance by being a victim of domestic violence. All right, so we talked about the notice of no fault eviction, the notice to terminate tenancy, and the demand. How is a landlord supposed to deliver these? So the service is by a notice or a demand may be served on a known tenant occupying the premises or by leaving a copy with some person, a family member above the age of 15. If you're thinking, well, my 10-year-old was actually given that, that's a defense. Show that they're 10. Serve it, you can serve by posting where it's taped to a door, taped, tacked, clipped to the front door or right beside the front door. But your landlord has to attempt personal service at least once on 2 separate days before that can be posted. Security deposit cannot be greater than 2 months' rent. A security deposit is not your landlord's money. It is money that you pay at the beginning of your tenancy to guarantee that you will do what the lease says you will do. So it's not your landlord's money. It's kind of held there to secure your performance. And it only becomes your landlord's money after your tenancy if it is withheld for proper reasons. So we're at this move out stage, right? We're talking about the end of tenancy. What are we going to do at the end of it? We're going to clean the residence, scrub it down. All right. I don't shoot the messenger here. Wipe out their fridge, clean under the burners, clean out the oven, clean the back of the cabinets. Is it going to be annoying? Yeah, sure is. But it's going to be a lot cheaper than what you see on a security deposit accounting for cleaning those items. If you have an opportunity to do a walkthrough, that'd be great. Also, take more pictures. Take the same pictures again that you took when you first moved in. Return the keys to your landlord, provide them with a forwarding address. Your former landlord has 30 or up to 60 days, if it's written into the lease agreement, to return your security deposit, but they only have to return that to the last known mailing address. Walk that out a step. If you don't provide a new mailing address, the last known mailing address is the apartment that you have just moved out of. Your former landlord doesn't have to track you down. They can just send it to the apartment you just moved out of. They've complied with the law. All right. So your landlord can keep the security deposit for damage beyond normal wear and tear. That's the usual deterioration which occurs when living in a residence. It is not careless or intentional destruction of property. So carpet's going to get worn down in foot traffic patterns, right? That's the usual wear and tear. Punching a hole in the wall, that's destruction of property. Can also keep your deposit for non-payment of rent, abandonment of the residence, non-payment of any utilities, repair work, or cleaning work that was contracted by you for you. If your landlord does not send you your deposit, you send a demand letter. You should send it with some kind of tracking. That way you can prove that it was actually delivered, and you need to keep a copy of it. If you do not receive a sufficient response to the demand, then you may choose to pursue a lawsuit for the wrongful withholding of the security deposit. Small claims actions are actions under $7,500. A lot of security deposits are going to fall in that range. So you can seek treble damages, meaning 3 times the amount of the wrongfully held deposit if you file a case within 1 year and willful withholding is found by the court. Early lease termination. When can we terminate our lease early? So a lot of the times it's going to be included in the lease agreement about what that process would be. Breach of the warranty of habitability without repair, or if it is fixed and there's a repeat violation within 6 months, then can terminate the lease early. As a victim survivor of gender-based violence, that is one of the protections available there, is they can terminate a lease without penalty. Military orders, act of God, so long as it's not your negligence. If you fall asleep with something on the stove and it catches fire, you're going to have problems. If lightning strikes your house and it catches fire, it's not really within your control. All right. We're in court now. Something has gone astray. Our landlord is trying to evict us. So things to think about before we open those doors and walk into the courtroom. First of all, an eviction case is called forcible entry and detainer. 19th century language, it's what we still use today. So if you're when you see a complaint, it would be complaint for forcible entry and detainer. You might say underneath in the parentheses, eviction. Right? This is the procedure for evictions in Colorado. Landlords have to use the court process. They cannot use self-help, meaning they can't remove your door. They can't come around with a sheet of plywood and just nail that sucker up there. That's not the way it works. If that does happen, contact the lawyer. You're going to have a legal claim. So that's the self-help I'm referring to. First step in this process is really receiving that notice or demand, whether that's the demand, the notice to terminate, or the notice of no fault eviction. What do you do if you receive these? So if it's a demand, if you receive SSI, SSDI, or cash assistance through Colorado Works, and you get a demand from your landlord, I am yelling right now to show how serious I am. Tell your landlord you get that assistance. Do it now, all right? I don't care if you told them 4 years ago when you moved in. They don't have a record of that, and the law has changed since then. Why am I so excited about this? Because if you don't, you will lose your right to mediation, right? If you get a demand from your landlord and you receive some kind of assistance, you need to tell them, I received SSI, I received SSDI, my family gets tenant. For non-payment, may want to start trying a rental assistance application or contact the landlord to work out a payment plan, especially if you are a victim survivor and you have a right to one. For other violations, provide your landlord with, if you have documentation that shows that it did not occur, show that documentation. If you can show that you fixed the problem, let's say it's, hey, your yard's a mess and you need to clean it up. Clean up the yard and show them that. If it's a substantial violation, this is going to be felony drug offenses, violent crime, public nuisance. So like renting a brothel, a bong shop, or a betting parlor out of your apartment is a problem. Don't do that. Provide your landlord with documentation showing that you do not commit the substantial violation. If it's a repeat violation, that means your landlord is saying, hey, you violated the same lease clause twice. If you have proof that you didn't, show them that. If it's a notice to terminate tenancy or a notice of no fault eviction, check to make sure it complies with your lease. Check to make sure it complies with the law. Contact your landlord to see if you can maybe work this out. Also, if you get the note, I mean, you also kind of in the back of your head, start thinking of a worst case scenario. All right, what am I going to do if I'm not able to work this out with my landlord? I had mentioned mediation before. Every demand for compliance must include this advisement. This is if you receive SSI, SSDI, or cash assistance through Colorado Works. You have a right to mediation prior to the landlord filing an eviction complaint. Mediation, it's dispute negotiation. There's a trained, neutral third party that's supposed to talk to you, talk to your landlord, see if you can work things out. As a tenant, you cannot waive your right to mediation in a lease agreement. Landlords are required to participate in mediation unless they are a 501c3 nonprofit that offers opportunities for mediation prior to filing an eviction, or 5 or fewer single-family rental homes and no more than 5 total rental units, including any single-family homes. If you tell your landlord, I receive SSI, I receive SSDI, and you have that in writing, it's in writing, you telling that you can't show that you told them. You can show, like told them verbally. You can show them an email. You can show that you sent a text message. You can show that you gave a note. And it also, the law requires that it be written. All right. It would be a defense against an eviction that your landlord did not schedule mediation. That would require, the law would require the case to be dismissed, your landlord to start over, and to schedule mediation. Well, it does.
It's got to be. I won't do nothing. So I'm sitting here going to pay my rent. They use you to do the, they got the little, what you call it, that JPay thing, you pay the rent and stuff like that. And I'm going to pay guys King Seekers. And then they said, it's declined. I said, you can decline. It's my rent. She said, no, they want $1,300, not $649. They didn't know nothing. So I said, okay, I said, I went to the advocate, talked to them, what's going on? I talked to my landlord. I've been here 7 years. Not one violation, nothing, I'm retired. I hate retirement. I'm going back to work. This is crazy. You're going to put you out on the streets for nothing? There's no reason. What I do? Show me something. And just like you said, there was no mediator because I was on the phone in the courtroom on the phone. And they sat me down in the booth over there and they talked and all this. And he said, lawyer said, hey, since you're on Social Security and all that and everything, said, if you out before that date, I won't put nothing on your rental history. I won't put an eviction on your rental history. I said, no, I said, do what you gotta do. I said, I don't know what you're talking about. I'm gonna find me an attorney. I got money. Don't get me wrong. But the point is, they just didn't tell me nothing for a whole month. I'm talking to them. At Harvard Point, I'm talking to these people every day. They didn't tell me about no rent increase, nothing. And I'm on a fixed income. So SSI, SSDI, Social Security Disability.
Sir, I don't mean to interrupt you, but at this point, I've got to get back to the presentation here, sir. I'm sorry that you've gone through that, though.
Point is, it can get you nothing.
Sir, I'm sorry that you've gone through that, but I'd like to get back to the presentation here, okay? So when we're getting to mediation, there is no cost to the tenant for that mediation. The landlord's required to pay their share, but this is free to tenants. And like I said, the scheduling of it must be conducted by a third party. So this is not a case where you tell your landlord, hey, I received this, and they're like, oh, great. Frank over from maintenance is going to sit in with us. He's going to be doing it. No, that's not how this works, right? It also is not something where their attorney sits in the middle of it and says, all right, I'm your landlord's attorney. I'm going to be mediating this between you today. No, it has to be a third party. Office of Dispute Resolution, ODR is the shorthand for that. They are mediators that will schedule mediation for the first available date, no later than 14 days after the landlord's request for mediation, so long as they're able to schedule that. On the ODR website, there is a special link for eviction mediations. I can't remember which House bill it was, but it'll say, I think, 1121 for, or 11, maybe 1120 for the eviction scheduling. So if we've gotten past the notice period, we've gotten past mediation, and our landlord is still claiming that the issue is not resolved or not resolved to their satisfaction, then the next step is going to be serving a summons and complaint. So the summons is telling you what day you must appear in court. In El Paso County, it's going to say non-appearance date. It's going to be really confusing because it's going to say you must appear at non-appearance on Tuesday at 8:30. And you go, what? If it's, where do I go if it's non-appearance? What that means is that by the close of business on that day, you have to either file an answer or reach a settlement with your landlord. If you don't take any action by the end of your return date, then you will be evicted, because that's what a default judgment is. One side is saying, Judge, we have a right to this legal relief, and the other side is silent. So the court's going to say, by default, I hear no reason not to give this party their legal relief. The complaint is setting forth the legal reasons why your landlord should win the case. All right. So summons must also contain a list of available resources with a website link and phone number for residential tenants to obtain civil legal aid and rent assistance. Colorado Legal Services contact information is in that paperwork. It is in every packet that landlords are required to give out. They also must give out a copy of a blank answer form, a document request form, and then a mediation form / affidavit. So the summons has to have an affidavit stating that mediation was conducted and was unsuccessful, or mediation was not conducted and must give the reason why. And then there's a statute on that. So once the landlord has, I hate the way I formatted this, sorry about that. Landlord has served the summons and complaint. You've got a court date now. What is the next step for you? Well, the next step is if you can reach out about a settlement, but if you're not going to do a settlement, then you must file an answer. This is your legal defenses in response to the complaint. This is not just what happened, okay? A court may be very sympathetic to the situation. I lost my job. I got in a car accident. I've been sick for the last 2 months. I had this family emergency, and the judge may understand completely why that knocked you on your butt. And a judge may feel all the sympathy for you, but the law doesn't. The law does not. The law in eviction cases does not have that human element of empathy. It does not have that sympathy in it. It is pretty black and white. So if you tell the court a heartfelt story of the trials and tribulations and how it's not just literally a miracle that you're still on your feet, the court's not going to be able to give you legal relief based upon that. They don't have the discretion to do that. If this is a non-payment case, your landlord must accept full payment up until a court enters a judgment, right? So that means that if you are in the middle of the eviction trial, you could put the money down on the table to your landlord or deposit it into the court registry. If that happens and the court confirms with the landlord it's the proper amount paid, then the law requires that the case be dismissed. Right? So even once an eviction case is filed, you have the opportunity to pay all amounts due according to the notice, as well as any rent that remains due up to that point. So, said this a couple times, answer is due by the close of business on the return date. So it's going to say if it's in El Paso County, You're hereby ordered to appear at non-appearance on day or month day at 8:30, 9 a.m., 9:30 a.m. You don't have to show up if it says non-appearance because it's saying non-appearance. You can file your answer up until 5 o'clock that day. Even if you are unrepresented, you can also file it electronically by registering to file an answer electronically. If you are raising a defense that the notice that your landlord is relying upon is improper, then you must raise that defense in the answer. Let's say you have a right to a 30-day demand and you get a 10-day demand. You must say in your answer that I didn't get the proper amount of time in my demand. You can't go to trial and for the first time saying, well, judge, actually the demand's not right here. You have to do that before the trial itself. Once you file an answer, the court's supposed to set the case for that hearing, that trial, 7 to 10 days after an answer is filed. And then also between filing the answer and the hearing itself, the court's supposed to order that you exchange all relevant documentation for the case. The hearing itself, you can choose to participate remotely by phone or video. That's not going to be held against you. All right. So you can appear in person or remotely for the hearing. You can change that choice. You have to say what you want to do on your answer. And let's say you pick in person and then your car breaks down. It's all, shoot, I got to figure this out. You can change that by filing notice with the court saying, I'm changing from in-person to remote. And you can do that up to 48 hours before your hearing. If you make that request within 48 hours, then the court has to give you permission first. You must have your evidence to the other party by the deadlines the court sets. If you show up to your hearing and you've got your binder and you've got everything there, but you haven't given it to the other side before the hearing, the court's probably not going to let you use it. Okay? At the hearing date, you must be prepared to prove your case that day, right? You must, if you have witnesses, they need to be there in person. They wrote out this statement for me, Judge. That's not evidence. That's hearsay, right? So if you have witnesses that have statements to make, they have to be present or remotely appear to make those statements. If you have physical evidence, you have documents, if you have receipts, you have to turn those over before the trial. Okay. You also have to be ready to make your arguments, to ask questions. If you're planning on that, you should write out a little guideline for yourself, okay? Just to make sure that you do. Am I saying you need a law degree to do this? No, but I'm saying make sure you write it out. That way you remember what is important for your arguments in your legal defenses. At the end of the hearing, the courts should issue a judgment for possession in favor of the plaintiff or the defendant. If the court issues a judgment for possession in favor of the plaintiff, that means the court's saying the landlord won the case. After that, 48 hours later, they're going to issue a writ of restitution. The writ of restitution, and once let me back up just a little bit. Once the court enters a judgment, you're evicted, right? But that doesn't mean that you're removed. Eviction is something that happens in court. Removals are what we think about a lot of the times when we're thinking about actually being physically put out. So the writ of restitution is what allows law enforcement to come into the residence, remove you, and turn the residence back over to your landlord. But they cannot execute the writ until 10 days or 30 days after the judgment. 30 days for folks on SSI, SSDI, cash assistance through Colorado Works, and victim survivors of gender-based violence. 10 days for everything else. There are exceptions for also some substantial violations don't get the 30 days, they get 10. I mentioned earlier, you come home and your landlord just decides they're going to nail the door shut or something like that. So a tenant who has been unlawfully removed or excluded may bring a civil action to restrain further violations, damages, costs. If a court finds that a landlord has unlawfully removed somebody, has conducted an illegal eviction, it's going to be the actual damages and either 3 times the monthly rent or $5,000, whichever is greater. The court may also order that the tenant move back in, right? This is not just literally, it is not just as extreme as me saying they nailed the door shut or something like that. If they change the locks, if they cut off the electric, if they cut off the water, if they cut off, if they decrease services with the intention and the goal of kind of constructively pushing you out, trying to evict you without a court order. make it so miserable that you leave on your own accord. That could fall into this as well. I don't want to promise that for every case because, like I said, I think on slide number 2, housing issues require a thoughtful analysis of both the law and the facts that apply. All right, fair housing. Federal and state level, this prohibits discrimination based upon race, color, disability, sex, sexual orientation, including transgender status, national origin, ancestry, religion, creed, marital status, and or familial status. There are exceptions here for owner-occupied buildings with 4 units or less, single-family housing sold or rented without the use of a broker, housing operated by organizations and private clubs that limit occupancy to members. Landlords are not allowed to discriminate against a tenant based on the source of income. So long as the income is derived from a lawful profession or occupation and the income or rental payments derived from any government or private assistance grant or loan program. What does that mean? It is no longer legal to say we don't rent to voucher recipients. We don't do vouchers. That's income discrimination. So very briefly, service animal versus emotional support animal. They are not the same thing, not even close. Service animals are trained to do work or perform tasks. They are covered by the Americans with Disabilities Act. They are not a pet, they are a medical device. An emotional support animal is not covered by the Americans with Disabilities Act. This is subject to fair housing protections for individuals with disabilities. In order to have an emotional support animal, you must get permission first. You have to make a reasonable accommodation request from your landlord to accommodate your disability by permitting your emotional support animal, right? A reasonable accommodation? Well, that's a great segue into this slide. It's discrimination to refuse to make reasonable accommodations necessary to afford a person with disabilities the equal opportunity to use and enjoy the residence. There's no magic language to make this request. We had just come off emotional support animals. Other examples would be, I would like a reserved parking space in the front of the parking lot because that would accommodate my disability. I'm requesting a grab bar be installed in the shower. It must be in writing, and it must state what the accommodation is that you are requesting. Not that, hey, I have this condition, help, I have this condition, can you do X, Y, and Z? Or please accommodate it with X, Y, and Z. The Mobile Home Park Act, these are additional rights for tenants in mobile home parks who own their homes or have equity in their homes. Requires a written lease agreement. Termination of tenancy must be caused. The demand is a 90-day cure period except for rent. Notice to quit is 90 days to move or sell the home. Security deposit is no greater than 1 month rent. Park management to enter mobile home spaces requires 72-hour notice. Here are lease requirements for homes in the park. Here's what constitutes cause for termination of a tenancy in a mobile home park for mobile home park owners. I'm going a little bit faster now so I can get to questions. Mobile home parks have most of them, if not all of them, to my knowledge, have rules and regulations. If you give the park permission to change the rules, they go into effect immediately. If you don't give your permission, then they go into effect 60 days later. Park management has no right to enter a homeowner's home without written consent. Written consent can be revoked at any time. Notice of entry must include date and time. Here's other provisions in the Mobile Home Park Act. I'm kind of blowing past these at this point, folks. You have it in the slides. For those online, if you've registered, should get a copy of the slides as well. You can go back and review these. The Mobile Home Park Dispute Resolution Act. MHPOP, Mobile Home Park Oversight Program. This is a administrative procedure to resolve disputes short of court between tenants and homeowners in the park and the landlord. All right. Got about 15 minutes for questions. Please keep in mind I can't answer specific legal questions. So if you get too detailed, you're going to get too much. Right. I'll also pull up the chat. Give me 1 second, folks online. All right. Yes, ma'am.
Is there any legislation around utilities and issue utility billing as far as being able to master bill that is sent to the landlord?
No, there's no right to see the master bill. They are allowed to kind of charge in like the batch charging ways of like, here it is, here's what we're kind of, here's our formula for calculating your share of the utilities. That is permitted. They're not allowed to make money on them, but I recognize that immediately. Like, that's why you saw the shoulder shrug, like, and I know, because I know what you're going to say. Well, how do you know if you don't have Roman? Don't shoot the messenger, please. Things can always change. Beginning January 2026, there are going to be, I don't know them well enough to speak on them. Also, they're not in effect, and I don't talk about stuff that's not in effect. There are going to be new consumer protections that roll out in 2026. So consumer protections are probably going to be where you get that answer quicker, in my mind, just because talking about billing and that practice is more of a consumer practice than it is a housing issue, right? Like, that's when we're talking about, like, I'm being charged for X as opposed to I don't have running water. To me, that falls more into like a consumer lens and a consumer analysis.
Okay, then, maybe you can tell me what this kind of issue would fall under, where, an amendment, to the lease was not presented and it requires more money monthly. And so the lease was signed. And then the landlord realizes that they forgot to put the amendment in there and is requiring the tenant to sign it. Is that a contract issue or?
Contract, yeah, that's a contract issue. I mean, that's landlord tenant. Most of what we're talking about are contract. Landlord tenant as a whole is contract law.
Oh.
Okay. Yes, there may be a tort, like a personal injury type tort here and there, but generally speaking, this is all contract law. The lease is a contract. A verbal agreement is a contract. So what you're describing sounds like a problem to me, because once the lease is signed, that's the full, most of the time when we sign a lease agreement, there's going to be some kind of boilerplate clause in a lease agreement that says entire agreement. This lease is the entire agreement. Nothing outside of the lease is a part of it. So that's why it's so important to read your lease through. I don't want to speak further on your situation because that's where I don't want to take a guess at what documentation you're describing. It sounds funky to me. I don't want to get too ahead of myself there. That sounds weird. I know that's the ironclad answer you were looking for of, funny. But I don't, without reading, but this is also why I don't want to get ahead of myself. I don't know what specifically we're talking about. You can tell me, and then I'll say that's legal advice and I can't give it right now. But that does sound off to me. Most lease agreements that I review in my experience have a paragraph towards the end of it and all of like the fine print boilerplate clauses. It says this written agreement is the entire agreement. No other promises, written or otherwise, included. Any changes must be in writing and signed by both parties. Something to that effect. Mm-hmm. So you are identifying an issue. I can't speak more to it because that would require me to read it, and this isn't the right setting. All right, I'm going to go around. I'll get to start back there. Yes, ma'am. Man, you're gonna make me go back to slide 85 here. It means I gotta find it. If we're in if you've been there if you have been a tenant for over 12 months, then yes, sorry, hold up. 90 days applies even if you're month to month if you've been there for over 12 months. Because there was that slide that says it doesn't apply to these. It shouldn't, but it could get weird if the buyer's not on notice that there are tenants.
The buyer is on notice, so.
Now you're getting into legal advice.
That's okay.
Okay, all right. I just want to make sure. Yeah.
Back on the landlord as the quiet enjoyment to the tenant's property.
It doesn't violate quiet enjoyment.
No, okay. Is this, so for that 90-day, does that just apply to like apartment buildings and multifamily homes? Or does it apply to single family?
It applies to every tenancy
Okay.
so go to the slide there that says it doesn't apply to anything. Oh, sorry. It's my bad. I wanted folks to have a resource here. Oh gosh, sorry. It applies to it, all properties, big and small. If you've been there for more than 12 months, it's not something funky. It's federal plus.
14 years.
Yeah, 14 years, 90 days. Unless we're talking about some of the other things. But if it's one of the, if it is one of the reasons in the notice of no fault eviction, then it's going to be 90 days.
So the 90 days would start with the landlord?
It starts with the notice.
So with the current landlord giving notice, or if the person who buys it and becomes a new landlord? Either one?
Yeah, either.
So your notice can be received from either one of those parties?
Yeah.
The current landlord? or the
Whoa.
person buying it?
No. It can be received by either one of those parties, assuming that either one of those parties owns the property at that time.
Okay.
Right? Like,
So whoever owns it then?
right, like
Okay.
current owner could give notice within 90-day period, ownership changes. That's fine. But prospective owner can't give notice because they have no right to possess the property.
Well, and that's my thinking, and my thinking is also they have no right to talk to me about it.
They're allowed to. They're fine. You're allowed to talk to me, right? We don't have a restraining order. You just don't have to answer. Just be careful. All right. Yes, ma'am.
Certain statutes or because there's mixing or there's warranted habitability, you can do a mutual amendment with your landlord.
Oh, yeah.
They agree.
Oh, yeah, absolutely.
Like in my lease, the liquidated damages, if I put in there and they agree that that clause is not applied to me as an early move out or unilateral move out, yeah, I can do that. And just clarify, and also that means that I will be like, if mine said I wanted my new lease date to be January 31st, it'll be just like Amina not renewing her lease. So I will go through the same process with the state, not the safety deposit.
You were thinking safe and secure. I hear you.
Colorado law, unless I
It's
hole in the wall, and did something crazy like that. They can agree.
yes.
Okay, because I just want to make that clear that because sometimes you'll have landlords that are willing to work with you, or because you got stuff on them, you can come to them with a mutual agreement and say da.
Absolutely. And
they'll rather not go to the court and allow you to get out.
right. So kind of going back to a question earlier, when a lot of leases have that kind of boilerplate clause, it says this is the entire agreement. Any amendments must be in writing and signed by both parties. All right. So to your question, yes, you are able to just negotiate with your landlord and come up to an agreement to change the terms of your lease. It's not required by law. That was the early termination section slide here is more of when is it required by law, but you're always, for the most part, you're able to make an amendment to the contract. If your landlord agrees to it, just get it in writing, and best practice is to have it signed. That was a really good question. All right, let me get to the one in the chat real quick. Can a landlord refuse rent if a tenant refused to pay a carport fee due to the landlord not having a valid contract offering This is too specific for me to answer. I would need to read the documentation. So this, I apologize, Ms. Battle, but that's just going to be, the answer is I don't know. Because I don't have enough information to answer that question right now. It is a very good question. I just don't have the information necessary to answer it because I would need to read read the documentation to be able to get there. Yes, ma'am.
Generally, what would you consider wear and tear? My carpet was ruined before I moved in, but I think it was clean ruined carpet, but I'm sure she's gonna try to charge me. I'm looking for it. And I don't want to pay for it, but I have to paint the walls after 7 years.
I don't know. I don't, it's going to be a different answer for everybody, right? What's wear and tear for a family of 4 versus a single person? Wear and tear with a family of 4 and them allowing a dog versus a single person. The question was, the question for those online was, what would be considered normal wear and tear after 7 years? A lot of stuff. It does.
And so then after that life expectancy,
I only before the guy had 8 years before me, but keys, my keys, I've been reading up a lot of stuff and it says that she had to give me a key for all the locks and all the doors. She didn't. She only gave me a key to one and it's stuck. I looked through my move-in stuff and I said it's stuck. But it finally stuck so bad one time I was afraid I wasn't going to be able to get into my dwelling. So, and she yells, screams at me every time I would ever tell her something didn't work. And so I had to go and get the lock street keyed and I would like to get reimbursed for that on my way out and for her to get a key.
So that's going to be, so what I'm not trying to be rude, but you are asking for legal advice right now of how do I navigate this situation of my lease saying I have a right to a key. She didn't give me a key. I rekeyed the locks. How do I go about getting reimbursement? Unfortunately, this is just not the right forum for me to be able to answer that question. But I would. Mm-hmm.
In a situation where one gave a warrant habitability written thing about the mold and there was no response for over a month. And then there was that, you can't prove that there's mold in there.
So again, you're asking me for legal advice. You're doing your landlord impression. Where would that go for? That would be a potential. One of the damages available in a warranty of habitability case would be the reduction in rental value. So one damage there would be that one potential damage in a lawsuit would be that you didn't take action for this amount of days. During these days, I lived in an uninhabitable property. So that would be something that could be sought in a warranty of habitability lawsuit.
And then when you were saying, anyway, 89 reason to terminate the tenancy, if that were at the end of a lease.
Yes. The notice of no fault has. They cannot list it for rent for the time period.
What?
I was trying to answer that. So they cannot list it for short-term or long-term rental. I believe it's 60 days. Hold on. Correct. There is a situation where the landlord's family member can assume occupancy. That is one of the reasons that the home can be, that's one of the reasons that a tenancy can be terminated. And they cannot list the premises for long-term or short-term rental for at least 90 days after the tenant's move-out date. If the tenancy is terminated because the landlord intends on removing the property from the rental market for the purpose of selling it. So if they do give that notice, then they can't put it up for sale for at least 90 days. Or up for rent for 90 days.
In that 90 days, the landlord doesn't have the ability to change their mind, correct?
No, it's saying in that 90-day period, they can't put it up for rent. I think so. I think that would be potentially, if somebody were, it's possible. I think that since they have, so a landlord gives a notice, a 90-day notice to terminate tenancy or a notice of no fault eviction for the purpose of removing it from the rental market and selling it, and then 10 days later, they just put it up for rent again. Well, I think it's pretty clear that they did not follow the no-fault evictions because they had no intention of selling the property as shown by their actions. But again, these are very fact-specific issues that it's not one size fits all, folks. It is not one size fits all. Yes. All right. Folks, we are out of time, so I'm going to check the chat for any last questions. I don't see any. Thank you all so much for your attention and also for being out today. This presentation doesn't happen if y'all aren't here. So thank you so much.
Thank you.
And thank you online for those who stayed with us.